Welcome back to the Deep Dive. Today we're tackling something that honestly can feel pretty overwhelming for a lot of folks. Navigating a Social Security disability claim. I mean, did you know the Social Security Administration, the SSA, denies something like 65% of initial disability claims?
Yeah, that's a huge number. And for so many people, getting that denial letter feels like hitting a brick wall. Like it's the end of the road.
Exactly.
Yeah.
But what if it doesn't have to be? This deep dive, well, think of it as your guide to turning that denial around.
Yeah.
We're focusing on mastering the SSD appeal forms. Our sources call them your most powerful weapon for overturning that decision.
Right. And our mission here is really to give you, the listener, a clear step-by-step approach so you can handle this complex process with, well, more confidence.
We've really dug into a comprehensive guide on filling out these forms, pulling out the exact steps that have worked for, countless others. And honestly, some of the details are surprising little nuances that most people miss, but they can actually make a huge difference.
That's so true. And it highlights why this is important. Look, the process is complex, no doubt about it. But with the right guidance, it's definitely manageable. Understanding the why behind each step is just as crucial as knowing what to do. It empowers you to build a much stronger case.
Okay, so let's get into it. We hear all the time about how complicated these SSD appeal forms are, how they just overwhelm people. And that leads to what our sources call costly mistakes.
It really does.
So this dive is about providing that systematic guidance, that roadmap to hopefully turn a denial into an approval.
Exactly. And the very first hurdle where so many people stumble right out of the gate is just understanding which appeal form to actually use, picking the right form. It's not just important, it's non-negotiable, really. Using the wrong one can mean automatic rejection, just like that.
Wow, automatic rejection. That's harsh. So, okay, what are the key forms we need to know about?
Well, the most common one you'll encounter first is Form SSA 561. That's the request for reconsideration.
Mm-hmm.
This is your starting point right after that initial denial. And importantly, it triggers a complete review of your case, but by a different examiner. That's key.
So fresh eyes looking at it.
Exactly. And it's your first real opportunity to submit more medical evidence, stuff you didn't have before, or that clarifies things.
Okay, so that's reconsideration. What if, that gets denied too? What's next?
Then you move up the ladder to Form HA 501. That's the request for hearing by an administrative law judge, or ALJ.
ALJ hearing, okay.
Right. This gets you a hearing in front of a judge, an administrative law judge, and they actually have the authority to overturn the previous decisions.
So they can say, nope, the first two reviewers got it wrong.
Precisely. There's also Form HA 520, the request for review of hearing decision order, but that's for appealing an ALJ's decision. So it's further down the line, less common as a first appeal step.
Got it. So first reconsideration, SSA 561, then potentially an ALJ hearing.
Yeah.
HA 501. All right, so you figure out the right form. But then comes step one in the actual process, that 60-day filing deadline. And you mentioned it has some surprising nuances.
Oh, absolutely. The absolute rule is crystal clear. You have exactly 60 days from the date you receive your denial notice to file that appeal.
And if you miss it?
If you miss it, you are almost always looking at starting the entire application process over from scratch. It's a hard deadline.
Oof. Okay, so what's the nuance?
Here's the interesting bit, what we call the effective 65 days detail. The SSA assumes you received your denial notice 5 days after the date printed on the letter.
So they build in mailing time.
Right. So effectively, you have 65 days from the date printed on the denial letter. And another small thing, if that final day, the 60th day after assumed receipt, lands on a weekend or a federal holiday,
You get to the next business day.
you got it until the next business day.
Okay, that 65-day effective window is helpful, but feels like maybe relying on it is risky.
Yeah.
How do you protect yourself?
Absolutely. Don't rely on pushing it to day 65. The biggest mistake is thinking those extra 5 days are guaranteed breathing room. They're an assumption. Best practice. Mark your calendar the day you get that letter. Set reminders, phone, computer, sticky notes, whatever works for you. Multiple reminders.
Good idea.
And then aim to submit everything at least 1 week before that official 60-day deadline hits. Build yourself a buffer.
That makes total sense. Create your own safety net and getting proof you submitted it on time.
Crucial. Always request a receipt or confirmation. If you're filing on paper, which sometimes you need to for lots of documents use certified mail, return receipt requested.
Right, that gives you undeniable proof of when they received it.
Exactly, because arguing for good cause if you're late, the SSA rarely accepts it. They have very strict definitions of what qualifies, like, severe illness preventing you from filing. So being proactive is paramount.
Okay, so mail the deadline, which brings us back briefly to step 2, choosing the correct form. We know SSA 561 for initial denial, HA 501 after reconsideration denial. Are there any common traps here? Maybe someone tries to appeal something else with these forms?
Yeah, that happens. You might get, say, an overpayment notice from SSA. That has a totally different appeal process and different forms. You can't use the 561 or 501 for that.
Ah, okay. Good distinction.
Another thing is trying to skip a step. You get the initial denial, you have to file for reconsideration first. You generally can't just jump straight to requesting an ALJ hearing. Trying to use the HA 501 when you should use the SSA 561, that'll get bounced right back.
Follow the process steps. Okay, so deadline met, correct form chosen. Now, step 3, gathering supporting evidence. And this is where you said people make that fatal flaw.
Yes, this is so important. The fatal flaw is simply resubmitting the exact same documents that got you denied in the first place. Our sources are clear that rarely work.
Because?
Yeah.
Why would they change their mind based on the same info?
Exactly. The SSA isn't looking for a repeat. They need new information, or evidence showing your condition has worsened, or maybe evidence that better explains your functional limitations, how your condition actually stops you from working in ways the initial file didn't capture.
So you need to show them why their first decision might have been wrong.
Precisely. And that means you absolutely must read your denial notice carefully. Don't just skim it.
Because it tells you why they denied you.
Yes. It spells out the specific reasons. Was it not enough medical evidence? Did they think you could still do some kind of work? Understanding the why lets you target your new evidence effectively.
Makes sense. So what kind of evidence are we talking about? Medical is obviously key.
Cornerstone, absolutely. You need updated treatment notes from all your doctors, therapists, specialists, especially recent visits. New test results, MRIs, CT scans, blood work if they show changes or confirm severity, reports from any new specialists you've seen, physical therapy notes, mental health records are often critical, and even just a list of your current medications and any dosage changes. It all builds the picture.
But it's not just medical records, right? You mentioned functional evidence.
Yes, this can be a real game changer. We're talking about statements from people who see you regularly, family, friends, maybe even former coworkers or supervisors.
What should those statements say?
They need to describe, in concrete terms, how your condition affects your day-to-day life and your ability to function in a work-like setting. Not just, he's in pain, but he can't sit for more than 15 minutes without having to stand and stretch due to back pain, or she has trouble remembering instructions due to her medication. Specific examples are powerful.
That adds a real-world perspective the medical files might miss.
It really does. Okay, moving to step 4. Actually completing the appeal forms. Precision is key here. Every single section matters. A good tip: read the whole form through before you write a single word. Plan your answers. Make sure everything lines up. Avoid contradicting yourself accidentally.
And consistency, you mentioned earlier, is vital. Making sure your name, social security number, dates, all that basic info matches your original application exactly.
Absolutely. Little inconsistencies can cause delays or raise, unnecessary questions. Then you get to the narrative sections. This is your chance to explain things in your own words.
Right, where you connect the dots for them.
Exactly. The advice here is crucial. Focus on specific examples of functional limitations. Don't just say, I have pain or I'm tired. Explain how that pain or fatigue stops you from doing things.
Can you give another example that, instead of just saying, my depression makes work hard?
Sure. Instead of that, you or supporting documents might say, my depression makes it impossible to concentrate on tasks for more than 30 minutes at a time, requires me to take unscheduled breaks multiple times a day due to crying spells, and I have difficulty interacting appropriately with supervisors due to irritability. See the difference? It's about the impact on workability.
Much clearer. It paints a picture of inability to work.
Oh, okay.
Which leads nicely into step 5. Really strengthening your case with that updated medical documentation. You said the SSA puts a lot of weight on recent evidence.
Tremendous weight, especially if it shows your condition has gotten worse or if you have new impairments that weren't there before. Fresh, targeted info can really make a difference.
Now, here's something interesting our sources mentioned. Doctors often don't know how to document for SSA purposes.
That's a huge point and a critical tip. Many doctors are focused on diagnosis and treatment, which is their job. But they might not realize the SSA needs specific details about functional limitations.
So, you, the applicant, might actually need to guide your doctor a bit. How do you even do that?
It's a delicate conversation, but you can approach it respectfully. You could say something like, Dr. Smith, for my disability appeal, Social Security really needs to understand how my condition limits my ability to function day to day. Could you make sure to include details in my notes about things like how long I can sit or stand, how much I can lift, or my difficulties with concentration?
So you're prompting them to think about specific functional areas.
Exactly. Key areas the SSA looks at are your ability to sit, stand, walk for sustained periods, lift, carry, push, pull objects, how much weight, how often, concentrate and maintain attention, interact appropriately with others like supervisors and coworkers, and adapt to workplace changes or stress. Getting those details documented is gold.
And sometimes maybe getting an independent medical examination, an IME, from a specialist who does understand SSA evaluations could be useful.
Yes, that can also be very valuable for an objective assessment, so it's often an additional expense unless the SSA orders one.
Okay, so evidence gathered, forms filled out meticulously. Step 6, submitting and tracking. Proof of delivery is the mantra here.
Absolutely. You've got options. Online submission is often convenient, gives you immediate confirmation, usually with a number. Save that confirmation number.
Definitely. And paper.
Paper is sometimes necessary if you have a ton of supporting documents you need to physically include. If you go that route, certified mail, return receipt requested, no question. That's your proof of when it arrived.
And keep copies of everything.
Everything. Our sources call it maintaining a master file. Copies of the forms you sent, copies of all the medical records, test results, letters, confirmation receipts, mailing receipts, everything. You need that detailed record in case anything comes up later.
Okay, submitted. But you're not done yet, right? Step 7 is strategic follow-up.
Correct. Don't just submit and wait passively. Be proactive. Within about 2 weeks, contact the SSA. Confirm they received your appeal. Try to get the name and contact info of the examiner assigned to your case, if possible.
Yeah, and keep checking on it.
Yes. Monitor your case status regularly. Use the online portal if they have one, or call periodically. And be hyper alert for any mail or calls from the SSA requesting more information or scheduling appointments.
Like a consultative examination?
Exactly. Missing one of those exams or failing to send back requested documents by their deadline, that can lead to an automatic denial of your appeal. It's serious.
And keep sending new evidence as you get it.
Yes. The evidence gathering doesn't stop. If you see your doctor and get new notes or have a new test, send it in. It can only strengthen your case even after you've filed the initial appeal papers. It's an ongoing process.
Okay, this is all incredibly helpful. Now let's quickly revisit those devastating mistakes to really hammer them home. Inconsistent information was one.
Huge one. If your appeal form says something different than your original application about, say, work history or onset date, it raises red flags. It makes them question your credibility. Always double-check against your original application.
Makes sense. And the other big one.
Failing to address the specific reasons they gave for denying you in the first place. Remember that denial letter. You have to respond to those points. Just sending the same stuff again and hoping for a different outcome. It's not a strategy. You need to provide the new evidence or clarification that tackles their stated reasons for saying no.
Got it. Respond directly to their concerns. Okay, let's pivot quickly to some frequently asked questions people might have right now. First, the big one. What if I really do miss that 60-day deadline?
Yeah, that's tough. Usually it means you have to start the whole application over from square one. You can ask for an extension based on good cause, but like we said, those are very rarely granted. Think serious illness, death in the family, SSA error high bars. Don't count on it.
Okay. Can I send in more evidence after I've already filed the appeal form?
Yes, absolutely. You can and you should. Keep sending relevant medical records, reports, anything new that supports your claim, all the way through the process until a final decision is made.
What about lawyers?
Yeah.
Do I absolutely need one to handle the appeal forms?
You can do it yourself. It's allowed. But statistically speaking, having representation, like a disability attorney, significantly increases your chances of success.
And how do they usually get paid?
Most work on contingency, meaning they only get paid a percentage of your back benefits if you win. If you don't win, you typically don't owe them attorney fees.
That's good to know. Now, the timeline. How long does this appeal stuff actually take, realistically?
Patience is needed, unfortunately. Reconsideration, that first step, usually takes about 3 to 6 months. If you have to go to an ALJ hearing, you could be looking at 12 to 18 months, maybe even longer, depending on where you live and the backlog.
Wow, okay. A year or more isn't unusual for the hearing stage.
Not at all. And if it goes beyond that to the appeals council or federal court, you're adding potentially years more.
Okay. What if the SSA sends me a letter asking for more information or documents.
Respond promptly and completely. Pay close attention to their deadlines. Missing them, again, can lead to denial. If you're unsure what they need, call them or contact your attorney immediately. Don't guess.
Right. And the last big question, can I work while my appeal is pending?
You can, but you have to be very careful. There's something called the Substantial Gainful Activity Limit, or SGA. It's a monthly earnings amount set by the SSA.
And if you earn over that?
If you earn over the SGA limit, the SSA might see that as proof you're able to work and therefore not disabled, which could torpedo your claim. It's a really tricky area. Best advice, talk to a disability attorney before you start working, even part-time, while your appeal is going on.
And that sounds like something you need specific advice on.
Yeah.
Okay. This has been an incredibly detailed look at what is, let's face it, a really challenging process.
It is.
But breaking it down like this, understanding the steps, the forms, the absolute need for precise, consistent, updated information, it really does feel like it can shift the odds, doesn't it? It takes it from feeling like a closed door to, well, a fight you can actually prepare for and potentially win.
It really does empower you. And it makes you think, doesn't it, about the whole journey of proving a disability within this kind of complex system.
Yeah.
How do you keep advocating for yourself month after month, sometimes year after year? How do you keep documenting conditions that might be invisible or fluctuate, dealing with all the bureaucracy and timelines? It really speaks volumes about the resilience and, frankly, the meticulousness someone needs just to make their case effectively. It's a testament, really, to that drive for recognition and support.